All right. Good afternoon. I'm Commissioner Jill Karmy. We're here for our family law represented attorney docket. I know I am pinch hitting on this one, except for a case I'm going to call last. That's a presentation order. I know the judge who regularly handles this docket couldn't be here today. So with that out there, let me just ask if there's any attorneys that want any cases set over for regular judges review. Anthony Diaz, and is it Casey or Cassie Lynn Hawkins?
I believe it's Casey.
Casey. And I have Miss Ernest here representing Christopher Diaz, I believe. And do I have Amy Powell? Oh, Amy Powers is coming in just quickly here. And I see Mr. Lawrence there. Thank you, Mr. Lawrence, for being present.
Yes.
Ms. Powers, we're calling your case first, Diaz v. Hawkins. I'm calling it first because I did put out a request just letting the parties know the regularly scheduled judge couldn't be present today. Some kind of pinch hitting here, except for one case that is a presentation. I know some of these have very long histories. If they would prefer it be set over to the regularly scheduled judge, I believe that is Ms. Ernest. All right, I'm still admitting people. Sorry, since I'm covering for this, we had multiple hosts for this and it kicked all of us out. So thank you everyone for being patient as we work through this. Let me go back to number 5, Christopher Diaz and Casey Hawkins. Ms. Powers, well, let's see if Ms. Powers is back with us. I have Ms. Ernest in the courtroom. And I was in the process of saying I had asked if there were any folks who wanted this to be rescheduled. Ms. Ernest, what is your position?
I'm asking the court to set this over to the 30th when we have another hearing scheduled. There are multiple issues. This is a very complex case. We have a restraining order motion, the GAL report that was just delivered over the weekend, and then my motion on the 30th. So I think it's appropriate to just set them all over given the circumstances.
And Your Honor, I would ask that the court go ahead on the restraining order issue. There's been contact that's been pretty upsetting to the child, and we don't want to put out further. We were advised by the clerk's office that you would be handling the docket today, and I had asked that they still docket it. Additionally, I was hoping to get the GAL's feedback prior to responding to the pending motion that's going to be heard July 30th. Ms. Ernest mentioned receiving a GAL report over the weekend. I did not, so I don't know if there is one out there.
Your Honor, I did provide Ms. Powers with a copy by email. I can send another copy to her.
I'd appreciate it. We did just move our email server over 2 weekends ago, so maybe there was a hiccup on our end, but I have not seen a GAL report. So actually, maybe that changes things slightly. I do know my client would like the restraining order issue heard today.
So it sounds like most issues, I don't know if the restraining order necessarily can be parsed out from the other issues. I guess, Ms. Ernest, your position on moving forward on the restraining order issue, but moving other things to a different date.
I think the issues are too intertwined. I do believe that it should be all heard together. There's currently not a temporary parenting plan in place, and I think it should all be part of the same discussion, the same hearing, the same order.
Ms. Powers, anything else you want the court to know?
Nothing additional.
Okay. I do think, I mean, to be fair to the parties, I did review declarations of Christopher Diaz in this matter. There was a responsive and a reply. I did have the guardian ad litem report. And all the parties are present today. That said, I think Mr. Diaz requesting to move this to a docket where I can already see Judge Basher has taken numerous notes on issues in our judicial odyssey system, including the restraining order. I think it would be appropriate to set this to the July 30th hearing. I think that'll also give Ms. Powers time to review that guardian ad litem report, so we don't have to piecemeal that as well. So I am going to go ahead and set you all over to July 30th at 1 o'clock.
Thank you.
Thank you.
Thank you.
Thank you. I did. Let me just set that aside. I have Mr. Olmos, your hand raised. Did you need to notify the court of something?
Yes, Judge Basher had struck all future court dates on our prior court date because me and Samantha had come to an agreement. I have submitted the agreed upon agreement. Samantha is going to respond, and I am also going to submit the proof of service. She was served electronically, which was signed off by the courts. So we've come to a mutual agreement. Has been submitted, but I still need to, like I mentioned, submit the proof of service, and she has to respond. But Judge Basher had previously struck all future court dates with the guardian ad litem. So I'm not quite sure why there was a court date today.
Well, he didn't strike the final, so and let me just make sure I have the other parties. I do see Ms. Lawrence there. Thank you for being here, and I did receive your report. Is Samantha Toney with us?
And I
Yes,
think
ma'am.
she's,
Go ahead, Ms. Toney. I apologize.
I'm here. I'm sorry.
Okay, so I'll just let the parties know, my notes from Judge Basher showed that he did strike all dates but left the final GAL review date. So I think that's what you all are here for, is for receipt of that GAL report, which has come in. It sounds like, well, I guess let me qualify that. It's come in as much as can be done at this time. Would that be better to say, Ms. Lawrence?
yes, because I'm stuck in the water, dead in the water.
Yep. And I did get a chance to read that report. I think it's as much as the guardian can do at this point, given outside factors. So let me ask Mr. Olmos and Ms. Toney, what are you asking any action from the court today, or are you both telling me that you've come to an agreement?
We've come to an agreement, ma'am, Your Honor.
The only issue I'm having is the protection order still being on the children, even though he wants to do 50-50. I'm not sure if that could be taken care of today.
No, there's no motions in front of me today. We really are just here for the review of the final GAL report. Here's what I'm going to do. Number one, I think the court's going to have to approve what you all propose. And but I'm not the judge who normally is on this docket. I have some concerns about what the settlement resolution between the parties could look like, given what I see are some pending ancillary matters. So I am going to set a future date for you all to get court approval for any orders that you both claim you're agreeing to. If there's a motion to rescind or put in place a protection order, please file it and we can hear it on that date. And then Ms. Lawrence, what I am going to state for your perspective, I would like you to stay engaged at this point. I would like you to stay on the case. I'll let Judge Basher make that final decision when we have a follow-up. But I don't anticipate you, absent some resolution of the criminal investigation, I'm not asking you to continue active investigation at this time. And we'll just kind of re-review your involvement at the next hearing to see where we are and if it's something that can be done. But I think it's important for this court to know how that does turn out, because that could impact whether the court approves a settlement that may or may not be in the children's best interest.
It's okay, buddy.
So, go ahead, Ms. Lawrence.
The concern is that Mr. Olmos is not engaged with law enforcement, and I was hoping that the court could have some impact with that particular matter, because I think that there's potentially three children who are very much in danger, given, the lack of resolution of the allegations here. And so I was hoping to be able to use that.
Yeah. So here's my position on that, though. I cannot require someone under criminal investigation to speak to law enforcement. I can't order that. I think that'd be a violation of his Fifth Amendment rights. So I can't order it. I would assume if law enforcement's involved that DSHS probably knows about this, or CPS, excuse me.
They
So
do.
I'm going to trust that right now it is in their hands. I'm not going to insert myself into it because I think, again, that could be a violation of Mr. Olmos's Fifth Amendment rights. So I'm going to let it play out the way that it should. But I would like to set a review date so that all of those issues can be looked at. Mr. Olmos, how much time do you need for agreed orders?
We're just looking to resolve it as soon as possible. Sorry. So I submitted the proposed order and you're saying I have to submit, another order?
I don't have proposed orders in front of me. Is there an order that you've submitted that you both have signed?
Not both. We haven't both signed it. I submitted a proposed order and I'm waiting for a response.
Okay.
She just hasn't had time to respond.
Okay. So why don't I set this out 2 weeks to July 30th at 1 o'clock? And we can review status of agreed orders that the court can review. And then we'll review any, I guess, updates from CPS or law enforcement. And Ms. Lawrence, I'll let Judge Vassar kind of make a call on you staying on after July 30th as well. Okay.
Okay.
Does that date work for the parties?
Yeah, July 30th, you said at 1 p.m.
Yep.
Sounds great.
Okay.
I'll move my appointments around. It'll work.
Okay, we can give you a different day, ma'am, if you can't do that.
Oh my gosh.
That's okay. It's just therapy. I'll just move it to like a earlier hour will be fine.
Okay, sounds good.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you. Number 4,
And then do I have-
Mitchell Stemmerman and Heather Fontes.
Hello, Your Honor. Tiffany Jensen. I represent Heather Fontes.
Okay.
I believe Mr. Stemmerman is also present. And
Yes,
I
I
saw
am.
Ms. Height earlier as well. If I could maybe update the court a little bit. I believe we're on for a final GAL review hearing. We have not yet received a final GAL report. However, the parties have been working on proposed final orders. And we have sent those around. There's a couple of potential revisions that might need to be made, but I think the parties have worked well together and we might have a final resolution of the matter. So that's sort of where we stand, I guess, at this point.
So Mr. Stemmerman, since you're representing yourself, do you essentially agree with that position?
Yes, Your Honor.
Okay. And Ms. Height, any input? It sounds like maybe we're just going to set a forward date and see where we're at.
Yes, that's my understanding as well, Your Honor. Thank you.
Okay. Ms. Jensen, since you were kind enough to go first, I'll come back to you and see if you're proposing a date for return when we might be able to take action on some of those items.
I would hope, Your Honor, that we could have it submitted to the court within the next couple of weeks. So, unfortunately, I'm out of the office on the 30th, which I've heard the court has been scheduling on that date. So maybe if we could do the following week, the 6th of August.
Okay.
And again, I anticipate that court date will not likely even be needed because we'll probably submit ex parte.
Okay. Mr. Stemmerman, does Tuesday, August 6th at 1 o'clock work for you?
Yes, Your Honor.
And Ms. Height?
Yes.
Okay, we will set this on then for August 6th at 1 o'clock.
Thank you,
Thank
Your
you.
Honor.
Okay, thank you.
then
Number 1 on the docket, Tracy Seals v. Keith Seals. I have Ms. Bliss on behalf of Tracy Seals and Georgia Petrie on behalf of Keith Seals.
Good afternoon, Your Honor.
Oh, good. Good afternoon. And as you know, I am filling in on this docket. I understand there's quite the history with this case. Why don't you all, I'll turn it over to you and you let me know where we're going today.
So, Your Honor, we're here on my client's motion for adequate cause petition for a petition to reopen the parenting plan. And we've submitted a proposed parenting plan and we are asking the court to adopt that. Bottom line is, as far as finding the adequate cause, Your Honor, the substantial change is a simple one. One of the daughters, Faith, I believe she is the eldest, is no longer living with either parent. She has filed a CHINS petition and is in the process of filing a petition for emancipation. So that is a substantial change all by itself. In addition to that, the parties never really adhered to the original parenting plan. And up until the filing of mom's protective order, they certainly weren't following that protective plan, that parenting plan. So we are asking for a finding of adequate cause and an adoption of our temporary parenting plan. Mom's protection order was denied. Dad has acknowledged that he had a relapse after 6 years of sobriety and now has 10 months of sobriety again. He is taking his recovery seriously and is adhering to all protocols. These are also not small children, Your Honor. They are 15 and 17. The youngers are a set of twins. My client has completed anger management classes, 2 parenting classes, and is in compliance with his alcohol and drug treatment that is ongoing. Mother tries to paint a negative picture of Faith, which is the oldest child. My client contends that Faith is a shift lead at her job. She maintains good grades and plays team volleyball. She works hard and she's very successful. So mom's portrayal of her is very inaccurate. Grace, on the other hand, is acting out on TikTok, drinking alcohol. Mom claims that there is no alcohol in her home, but yet the pictures that we submitted to the court show something very different. Neither of these parents are going to be up for any awards, Your Honor. They both have difficult pasts. They both have made poor choices in their lives. But really, they only have 1 in 3 years left with these kids. You know, things are going to change really quick over those years. Our goal here is to ensure that those remaining years are peaceful for these kids. It's our position that our proposed parenting plan will accomplish that. And for the court's information, the next CHINS hearing is set for 7/31, at which time they will also be considering and reviewing the petition for emancipation.
Thank you. Ms. Bliss, go ahead.
Thank you, Your Honor. For the record, Carly Bliss on behalf of Tracy Mathers, formerly known as Tracy Seals. What I encourage the court to do is look at the former parenting plan entered in this matter in March of 2016. In there lays out Mr.'s path to restoration. And it's literally in a specific section all on its own. It says road to restoration. In there it says prior to father bringing any sort of petition to the court for additional visitation, he has to complete that section. And he has failed to do so. So in looking in that specific section, it specifically requires 1 year of drug-free, proven by hair follicle tests every 3 months. He has failed to do that and even admits to not being sober for a year. Looking next, a psychosexual evaluation. And I think this is very important for the court to consider, especially considering his recent grudges. And this isn't just something, minimal or something to that effect. This is forcible complaint, and he is currently under investigation, being charged. The PC statement was very concerning. And I think that obviously speaks to not only his history of sexual misconduct, but his ongoing and continuing sexual misconduct. The fact that this hasn't been completed is very concerning. Looking next to completing a drug and alcohol evaluation, has yet to provide that to the court or to my client, admits to relapsing. So again, there's previous 191 findings for substance use. It's clear that he has again relapsed just recently and is now saying that he has a basis to modify this parenting plan without completing any of these required provisions under his current parenting plan. In looking in the parenting plan, again, there's 191 findings for neglect. There's 191 findings for an emotional, physical impairment that impairs his ability to parent his children. Again, alcohol and substance abuse and abusive use of conflict. And my client highlights this in her declaration that this is continuing. He's using these children to cause conflict. My client provides that although we do have some teenage girls, they definitely have taken advantage of the fact that they've had separated parents. When one parent implements rules in their household, they attempt to run to the other parent. And my client acknowledges for the fact that for the last several years, while Mr. was sober and while there wasn't any concerns brought to her attention, she was more lenient with the parenting plan because she did want him to have a relationship with his children. However, she provides for you that once these concerning behaviors began again, she took a step back and said, yeah, this isn't in the best interest of our children. And that's very apparent. If you look at the history of this case, if you look at the history, and I believe Your Honor may have heard the protection order in this matter as well. There's been a lot of concerning behaviors on behalf of father. Not only has he relapsed, has these criminal charges pending against him, he physically assaulted one of the child. He introduced this child to marijuana and alcohol in his household.
Objection, Your Honor, there's no proof of that.
Go ahead, Ms. Bliss.
Thank you, Judge. In my client's declaration, she cites to the fact that Mr. has relapsed on, and he even acknowledges he's relapsed on drinking alcohol and mushrooms. And the child at issue, primary issue in this case, Grace, has a recent history of alcohol use and marijuana use that began once she began staying primarily with Mr. My client provides for the court that since returning to her care, once the protection order was entered initially, Grace has made a marked improvement. She's doing well in school. Contrary to father's allegations, and I did see he provided one picture in his responsive or his reply declaration that shows her in a bikini and claims that she's drinking or talking about drinking. That's been failed to be provided to the court. And my client says that's absolutely not what was happening. Again, looking to the allegations of mother, which I don't think are appropriate, but nevertheless, there's allegations that she drinks. And what do they do to provide substantiation of that? They provide one photograph of a Valentine's Day, and it's clear that it was from Valentine's Day. So in February, I have a bottle of wine on the table. Okay. What else do they provide? They provide my client and her husband at a festival or at a concert with a liquid death, which is water. And it appears there may have been a White Claw also photographed in there. None of that is providing that there's alcohol in the home. And there's nothing that says that my client is providing this to the child. But what you do have before you is substantial issues in father's home. And what does he ask for the court? He's asking for the court for a major change to the parenting plan, which provides my client primary custody of these children, has substantial 191 findings, has supervised visits of Mr. And has this road to restoration, which he's failed to comply with. What is he asking the court to make a decision of? He's asking the court to order that Faith and Grace be in his primary custody and to provide visitation with mother at their request. He fails to provide any sort of visitation for Hope and acknowledges Hope is safe with my client, but my client's a danger to these other two children. I fail to see the logic and I fail to see how that's appropriate. What is required into the court when making a determination as to adequate cause? Even if the court were to throw out the former parenting plan, which laid out every single requirement Mr.'s to complete prior to coming before the court. If the court disregards that, the court is tasked with finding, is there a substantial change of circumstance with my client, the non-moving party, or the children? Sure, there may be some substantial change of circumstance from Grace when she with Faith from when she was 3 years old when this parenting plan was entered, but I think that that's natural, and I don't think that that was not anticipated by the court at the time the final parenting plan was entered. What I'm asking the court today is to deny adequate cause, deny the request for a change to the parenting plan, and deny the requests of Mr. at this time. My client did incur substantial attorney's fees in responding to this action. If the denial is approved, we are asking the court for an award of attorney's fees, as it's clear that Mr. has not only failed to comply with his road to restoration, but there's significant concerns regarding his household at this time. It is not only dangerous to return or to provide any additional time with with the children and Mr. at this point, given the criminal allegations currently against him and given the substance use current relapse, 10 months ago or not, we're less than a year of a relapse of someone who has a significant history of substance use. There's significant concerns. If the court is going to find adequate cause today, we're asking that no change be made to the parenting plan pending some sort of an investigation from either a family court investigator or a guardian ad litem.
Just briefly, Your Honor. With regard to what counsel is saying, it doesn't dismiss the fact that under the parenting plan, Faith is to be in her client's custody, and currently Faith is not in her custody. That alone is a substantial change in circumstance in mom's house. Where is there a detriment to Faith in mom's house? We don't know. That's being investigated under the Chin's petition. So that enough, and that alone, the fact that one of the children that is awarded to mom in the parenting plan is no longer in mom's custody is sufficient change in circumstances to find adequate cause. So everything she says is basically irrelevant because it completely ignores the fact that one of the children addressed in the final parenting plan is no longer in the custody of the custodial parent. So that's enough to open this up. I have no objection to a GAL. I'm perfectly fine with having a GAL investigate this case, and I think that would have been our next move. I don't believe that supervised visitation is appropriate as counsel stated at the time that the final parenting plan was entered. Faith, I think, was 3, or the youngers were 3. Long passage of time, and these children are no longer small, unable to speak out for themselves, defend themselves, or know how to contact emergency help if needed. The parties, up until my client's relapse, had been doing unsupervised visits, not following the parenting plan. There were periods of time when, yes, the children were going back and forth, living with my client, living with her client, and that was the way this went. All of those are long-term deviations from a parenting plan. I'm not saying my client is without fault. My client acknowledges his fault. I'm concerned. There is a history here with her husband, allegations of her husband abusing one of the children.
And I would object to that. There's no history, nor has there been any findings of that.
But the allegations exist.
Give it its appropriate weight.
So, Your Honor, at a very minimum, the court must find adequate cause based on the current circumstances of all the parties and the children. And in addition, we're asking that the court adopt a reasonable parenting plan that reflects what the parties were doing prior to the filing of the protection order, which was denied by Your Honor.
Okay, give me just a minute. What day did you say the Chin's petition is being heard again?
My understanding is there's a hearing on July 30th or 31st.
Your Honor, it was my understanding the child was dismissing the petition on that date.
I was gonna just pull that up real quick.
All I know is that the last time the fact-finding hearing was going to be held, it was set over at the request of the minor child because of a pending emancipation petition.
So I think, and this is kind of what I was looking at, what we have in place over on that side. So at least as it pertains to Faith, when the parties were last there, the court specifically ruled fathers to have no unsupervised visits with Faith. I'm not going to disrupt that. So I just wanted to make sure I was right on that. So here's my thought on this. First, I think that at least at this stage, based on a change in custodial status and or a child's request for custodial status who is 17 and otherwise previously covered under the parenting plan, I think there is adequate cause to review the parenting plan. What I am not going to do today, though, is change the parenting plan that's it currently in effect. I'm a little bit floored that a gentleman who's under criminal investigation and or charges for is asking to be the custodial parent. So that's not going to happen today. I do not feel that that is in the children's best interest. So I'm absolutely not adopting his proposed parenting plan. I am going to appoint a GAL to investigate, and we can set a hearing on temporary orders at that time. And frankly, I don't know if the new parenting plan is going to be more or less beneficial to dad, because I'm not basing my decision on any substantial betterment or change in his circumstances. This is purely based on a child who seems to be seeking emancipation. And I do think under the statutory language, that's enough for me to at least find adequate cause. And I think we're going to have to track this with her decision on the Chin's petition to some degree as well. And maybe she's not included in this next go around. I don't know. But let me hear from the attorneys on GAL payment. Is this something where your clients have the ability to split the cost of that? I have not looked at anyone's income, so I'm asking.
I believe splitting it 50-50 would be appropriate, Your Honor.
And I guess I would just ask the court to reserve on that and require both parties to provide some sort of financial information. Obviously, the final child support worksheets entered in this matter were, 8 years ago at this point. I guarantee both parties' financial status has changed, but I don't think anything's been provided to the court to provide if this is a county pay case or if both of them are employed. I don't think any of that information has been provided. So I would ask the court, obviously appoint a GAL today, but maybe reserve on the payment for maybe presentation, and then at that point we provide financials for our clients and then a decision be made.
I would have no objection to that.
Okay. I usually like the GALs to know whether they're accepting county pay or private pay. Do you all have any, and then we could reserve on the apportionment, but I guess, do you have any, are either of you going to ask for this to be a county pay GAL? Do you truly believe your clients are indigent?
No, my client is not indigent.
I believe both are. I know at least my client is employed, so I think she would qualify for private pay at least at this
Here's
point.
what I'm going to do for purposes of the order. I'm going to indicate private pay, but that the allocation, the GAL is going to want something to get started. I'm going to say that the initial payment will be 50-50, but I'm going to reserve on apportionment beyond that. From after further financials and argument. And then who would be the next three?
The next three are Karen Lawrence, Ann Height, and Keith Lawrence.
I'm sorry, I only heard Karen Lawrence.
So Karen Lawrence, and then who's the next?
Ann Height.
Ann Height.
And Keith Lawrence.
And then Keith Lawrence. Does anyone want to strike Karen Lawrence?
Yes.
Okay. Does anyone want to strike Ann Height?
I'm fine with Ann Height.
I would prefer Keith Lawrence.
I'm not striking Ann Height, so I think she's next on the list.
Okay, so are we taking Ann Height?
That would be my request.
Okay.
I would request Keith Lawrence.
You can't strike two, counsel. You can only strike one.
I'm going to go the person next on the list. That is not being struck by opposing counsel. That is Ann Height. Now, I usually handle the pro se family law matters, and I do the GAL orders. Do you all do those on this docket?
Yes, we do.
Yes, we do.
Now, that's music to my ears. Do you want me, and then will someone prepare the finding of adequate cause, specifically noting not adopting a new parenting plan? Current parenting plan is to stay in effect until a new one is put into place, and we'll set that hearing at a later date. I should get you review dates for the GALs.
Your Honor, my understanding was that there were some interim orders. Were there? that the visits would not be supervised. My client was allowed phone contact. I mean, I'm fine with coming up with a different kind of parenting plan, but to continue supervised visits when they haven't been supervised in over 10 years, just doesn't make a lot of sense.
Well,
It's gonna be strange for the kids.
well, the judge in the Chin's case, didn't they state supervised or did I say unsupervised?
They deferred it to you.
No, that's not what they did. What? No, yeah, I thought the judge said no unsupervised. I'm gonna go back and look at it. The court rules, and this is Judge Scudder on July 3rd. Court rules, father is to have no unsupervised visits with the child at this time. So I'm sticking with that. I'm not going to make a change unless a GAL recommends that change. So again, I'm not making any changes to the prior parenting plan until there's further investigation.
Okay.
Okay, what date do you all want to set to return?
For presentation or for a GAL review?
Let's do both. Do you expect to set this on for presentation or just ex parte signature?
I think we should set it on for a presentation.
Okay. So let's start with that. Do you want the July 30th date?
I'm scheduled to be out of the office that week, so I request maybe the week after. I don't imagine unless council can get it done in a week, but I think maybe the week after is probably safer.
August 6th is perfectly fine with me, Your Honor.
Okay, let's do presentation August 6th at 1 o'clock. And then for your GAL order, any proposed dates? I'm really fine with whatever you all agree to.
I'm sorry. Oh, the review of the GAL hearing. Well, we gotta do 90 days out, right?
I think it's 120 under the new rules and order.
For the final, I think there's 3 dates we pick. If I recall correctly, I don't have the order up in front of me, but we'll do I think was it a 120, a 90, and a
30 is usually for compliance to make sure that the GA has been paid.
Okay.
So if we want to do maybe September 10 for that GAL compliance, that's 30 days after our presentation.
I'm good with that.
And then maybe October 15 for an interim review.
Okay.
And then a final December 10. I guess I think that would be about 120 days.
I'm still on October 15.
Oh. That's fine.
Sorry that you said December.
Maybe December 10. I think that's a good. That's about 120 days. So maybe the final GAL report due December 3rd, and then on the 10th the hearing.
That's fine with me.
That works for the court. Okay.
Yeah, that works.
Is there anything else the parties need to prepare those orders?
I don't think so, Your Honor, not today.
Is Your Honor covering that August 6th docket, or are you going to pop on for a quick, or should we set it specifically to one of your presentation dockets?
That's a great question. I'll check with Judge Basher. Let's keep it on there, and then I'll let. I don't typically have docket at 1 o'clock, so I'll keep track of it.
And just since we are having a presentation date, I would just again request, I know you made your kind of interim ruling of 50-50, but then we could come back and readdress apportionment. I'm going to renew my request since we are coming back already on August 6th. Is it possible that we file financials in the meantime and just leave those spots blank, and then Your Honor can review those financials prior to that hearing and then plug in percentages at that point? My concern is doing 50-50 and then having to revisit it later.
Yeah, I think that makes sense, because my initial thought was that I would be entering these orders today and we'd come back at 30 days and the GAO would say, no one's paid me because Your Honor didn't apportion. Right. But you all are doing the orders and they won't be entered till the 6th. Let's go ahead and at that hearing, we will address apportionment. But it sounds like it's going to be private pay, so I feel pretty comfortable checking that box.
Okay.
Very good. I don't have any other questions unless Ms. Petrie does.
I do not.
Okay. Thank you.
Thank you, Judge.
Okay.
McLean and myself talked about around there. But I don't know if you want to handle that. I don't know at this point, it almost appears that she got another scholarship and there aren't any other costs. So with the way the order rules, we're not exactly sure what to do here.
Well, yeah, I mean, I absolutely ordered that Mr. McCoy was responsible for post-secondary support because I said it was appropriate under the facts of the law. Then I indicated that because it was unlikely monthly payments would be made, there was a weighted distribution from the home to cover that. And I think it is common sense that the amount of what has been paid for post-secondary support be provided to Mr. McCoy. Because if she's not paying anything, I think that does tip the balance sheet. So I am going to include,
May I ask another clarifying question?
Just a second. Let me just finish this thought.
Okay.
There should be verification provided that post-secondary support was paid. Because I think the indication was petitioner and respondent shall be responsible for 50% each of the outstanding expenses for post-secondary costs of room and board subject to limitations, and that includes all of the requirements for documentation.
Okay, so then moving forward, my concern would be is Mr. McCoy's attempts to take a second run at the court's order if we don't have an amount specified as far as what should be paid, or him attempting to argue that he owes her money down the line, or I mean, that's my concern, is an end run around the court's weighted division and him trying to upset what the court has done and argue then that my client owes him money. So how do we?
I'm confused by that concern. Go.
Well, because you've provided a weighted division, but you've not nomenclatured the value of that.
Correct. She is correct there.
So let's say my client has $15,000 out of pocket, and he doesn't think that equates to what his 50% share was, and therefore he's going to try and do an end run and say that my client then owes him money. How do I protect my client against that when the court hasn't identified?
Tell me a scenario where before a child is done with college, the parents know every dollar and cent that's going to be spent.
Your Honor, I think that opposing counsel and I talked about this, and Noel, if I'm not wrong here, I believe we both agreed that his portion would be just under 15,000, half. And you had an exact figure, so we have one.
So the information that Your Honor has before you in my client's court declaration and the supporting documentation from, I think it's Montana State, is that the expectation is that her cost for the final year for 24-25 would be $25,534,000, of which then the child's responsible for a third and the parents would be responsible for the remaining 2/3. And you indicated that they were to split that. So that does not equate to $15,000. So I guess I just want to make sure that we've got a value in there so that if the court
then your valuation that it is the $25,000, you take a third off the top, and the 50-50 remaining is 1/3 and 1/3.
Correct.
Yeah. That's what he owes. And that's less than 50,000.
But that finding needs to be memorialized then, if the court's going to require that she provide proof.
Yeah.
So if the court saying
those are two different things though. I'm confused what you're asking me to do, because he is responsible for 50% of it.
Correct.
You're not ordering him to pay her directly. You've given her a weighted division of assets and debt.
I know what I have.
So if he's responsible for 12,000 and she
Not
pays
responsible for
3,000, 3,000, then there's a problem because you did a weighted distribution to her for expenses that she never paid.
It doesn't matter what she is responsible. He is responsible for 50% individually. She's responsible for 50% of the 2/3.
The court didn't order, the court, okay, with all due respect, your honor's ruling is that he doesn't have to pay anything. My client has to pay 100% of it.
I understand. He is responsible, but she is getting the value of that money towards the home.
Correct.
Okay, so the number on that, so Noelle, go back to Ms. McLean, excuse me for being.
That's okay, you can call me Noelle.
Give me the first number. You said 25,000.
$534. When you divide that by 3, that means everybody's responsibility is $8,511.
Yes.
Okay, so mother just needs to show that she has paid $17,022.66 for both her portion and father's portion.
And what if she pays more?
And what if she pays less? This is kind of the problem.
It's not the problem because I am saying he is responsible based on the numbers that you all presented. We expect that it's going to be 25,000 and some for the remainder, and she's going to pay 1/3 of it, and they're going to split the remainder. So he is going to be responsible for the weighted distribution that I am shifting over to her side is $8,511.33.
Okay. So if it's less than that she pays, then are you saying that he can come back and argue that, or are you saying that that's all taken into consideration in the global analysis of your ruling and that this is what everybody's getting? You're relying on those numbers.
Yes.
And then if that's the case, then why do we need to provide proof?
Totally agree with you.
Yeah, so I guess I just need clarification here. So if wife actually pays 0 towards post-secondary and father got a weighted she got a weighted.
But how would she pay 0 for post-secondary?
Because the daughter has been getting scholarships that pay for everything. And there's no information on that at this time.
I'm not aware of her receiving any other scholarships at this point. We did outline in the declaration the one-time Burger King Award, which was a substantial award, which covered essentially the majority of her first full year at out-of-state tuition. And I think that there were some other smaller grants and tuition payments that she received.
Okay. Yeah, I'm just going to go back to
sure.
In the entirety of everyone's college career, there could be grants, scholarships, increases in tuition, decreases in tuition. At the time when the case was presented, the valuation estimate was this $25,000 to finish. And she has scholarships, we believe, and more likely than not, the evidence showed that she's going to get a scholarship for 1/3 of those. So what I'm saying here today, his responsibility of what we believe is 50% is $8,511.33. That's the number. It could be less, it could be more, but that's what we value that 50% sitting here today. So that's the number we're going to use for this order. If mom may have to pay more, mom may pay less. I don't know, but this is the best guess we have sitting here today.
Okay, I'm fine with that, Your Honor, as long as we get the verification that it's been paid. And that can come to me.
I think that's fine. It's not going to change these numbers, but I think it's fine to require that Mr. McCoy, because this is essentially being taken out of his profits in the divorce, I think it's fine for the court to also say, yeah, Mr. McCoy should get notification that post-secondary support was paid. It just says, the language is there should be some verification provided that post-secondary support was paid. Period.
Okay. But that's not a basis to reopen the decree or the property division.
That is not my ruling at all, correct? I am valuing his 50% at $8,511.33.
Okay, so are you okay if I include language in the findings that that's not a basis to reopen the property division?
I don't think that you can do that, Your Honor, because I mean, potentially that's a CR 60.
Yeah, I don't think that that's necessary. If someone tries to bring it up and reopen, I'll be happy to jump on and we can talk about it then, but.
And I'm assuming that this is memorialized, at least in the clerk's minutes.
It is in the clerk's minutes. Okay.
Thank you.
Let's move on to commercial property. We've got 1 through 5. This is on page 2 of the objections. Go ahead, Ms. Jeffers.
I'm sorry, Your Honor. I was just going to refer you. It looks like I'm looking at page 4 of the findings and conclusions, and I just need to take a look and see if it's also in the final divorce order, because I don't think it is. I think it's just on the balance sheet.
No, it's in the final divorce order at paragraph. It's also in the findings at paragraph 22C, and in the final decree at 20C.
I don't have that. Are you looking at my red line
language?
I mean, I guess
I'm sorry, 22C and 20C. So the
page 6 of 7 in the final divorce decree, correct?
I don't see it there.
Okay, I'm sorry. It's 22C and 20C that are the same. So we're just talking about 11B now. Is that correct?
We're talking about 11B in the findings and conclusion, but I don't see anything that is identical to that in the final divorce order. I'm looking at 20. Hello?
Yeah, what are you, so I'm going through respondents' objections to petitioner's proposed final orders, and we're now on to commercial property. So page 2 of your objections, and there's 5 bullet points. And you're trying to figure out where those are in the final orders?
They're in paragraph 11B.
Yes, in the findings. I don't think that is in the final orders. You said it's under 20C, but I
misspoke. I just said that I misspoke. It's just 11B, and it's a finding, and it doesn't have to be reciprocated in a decree. We've got the balance sheet and the final figures in the decree.
No, I understand that. I was just, when you said it was there, I was looking for it. I couldn't find it.
Okay. So we're on page 4 of 9, if I'm not mistaken, of the findings.
Correct.
And we're on 11B. And Ms. McLean had proposed some language, and it looks like the request is to redline that out. And then referring back to the objections, go ahead, Ms. Jeffers, what is your proposal?
Yeah, so that's just, at this point, Your Honor, I wanted to go ahead and redline that out. It looks like we're both in agreement that the payment she made towards the commercial property, he should be given credit for the rent that was paid for that. That's what her language is here. It just doesn't go all the way to current time. So she was paying the $13.01 a month, and she received rent in the amount of $600 per month from February to May. So that's $11,216 that should come out of the total amount that was owed on the building, and that is on the balance sheet as $20,235. In addition, she received rent from June 2023, noting that the building was paid off, so she wasn't making any more payments at that time, in May of 2023. So she was getting $625 a month for $87.50. So I took the amount that was owed on the property, the principal, and minus those rent payments, and I get $269.
So, okay, first off, if Your Honor.
Just a second. Mr. McCoy, I'm going to need you to mute. We're getting some wind feedback from you.
Okay.
Okay. Go ahead, Ms. McLean.
The question, Ms. Jeffers confabulates two different arguments. The first off is that there is a community valued debt at the time. There's two debts on the commercial property. One was to Farmers Federal Credit Union. The other is to Daryl McLean. During the course of the separation, the Farmers was paid off. Daryl McLean is still owed. So the amount of the Farmers at the time of separation was $20,235, and the debt to Daryl McLean was $13,500. So your Honor's ruling on page 4 talks specifically about my client being reimbursed for her separate payments for payments and the like above and beyond, and repairs, property taxes, insurance, and whatnot. All of those expenses above and beyond those mortgage payments or the rental payments. So that's what this paragraph does. Keep in mind that we were before your Honor 4 months ago now. My client continues to pay out of pocket, mind you, and these amounts are not included in these orders. She continues to pay the property insurance, the property taxes, the water, sewer, garbage, electrical. She's paid electrical repairs. All of those monies are above and beyond the $600 per month that she's receiving, and the balance of what that full $600 is going to pay Daryl McLean. So she's having to pay all of these additional expenses above and beyond that, which this court hasn't even taken into consideration. Arguably, that line should be more than the $14,000, and quite frankly, I don't know how we provide for the fact that we've had another 4 months of payments by my client. I could certainly submit those to the court. I could have her submit those numbers to me, and we could change that as it relates to the amounts that would be coming to her and to Mr. McCoy from the escrow. But the court did specifically order that after petitioner, let's see, you indicate it should be sold, provided that such division as far as 50-50 is made after petitioner is reimbursed for debts paid post-separation to Farmers Federal Credit Union and to Daryl McLean, and after any debts on the properties are paid off. So that line is appropriate, and I provided that in our balance sheet, and that's what we pled, and you specifically ordered that was to continue at the 14, well, you didn't say 14,020, but that's what we had argued. And I understood that you were working off of our proposed orders and our balance sheet. And so I understood that those amounts stayed. You struck the waste claims, but you kept the arguments as it related to her post-separation payments and the expenses that she had to pay as far as repairs.
And so, Your Honor, if you look at my spreadsheet, the debt to Mr. McLean is still on there. The repairs are still on there. So we're just talking about the mortgage payoff and the rent payment, which she was supposed to get credit for. This is the correct number. That $20,235 should be $269. And then the debt for Mr. McLean and the repair debt, those are both in here in my proposed spreadsheet.
Mm-hmm.
So I mean, that is the proper amount. I'm not sure, where council came up with this $14,000. She apparently just stopped counting the rents for the last year or so, but that's not appropriate. It wasn't the ruling. And I think we both agree on those rent numbers and those months received. So
I didn't stop counting the rent numbers. Those are supported in the documents that we've provided to the court. If you take a look at our exhibit number 16 and 18, you'll see the payments that she had been making on the insurance, the property taxes, the repairs, the monthly electrical, water, sewer, garbage payments. All of those are outlined in the exhibits that we had before the court, and Your Honor didn't say that you were discounting our numbers. It's also improper to put that in the community portion line when it was separate payments that my client made after the rental payments, which I've accounted for in the finding as well as in the balance sheet. If you look at Ms. Jeffers' balance sheet, you'll note under the analysis section, there is no net payments to the 14th for Farmers Federal Credit Union, and there are no expense lines. She's taken those completely out.
I have taken those completely out because that was all community debt and community assets.
These are expenses that my client has been paying out of her pocket with the assistance of her
with
mother.
the money.
There was $600. The monthly payments for the Farmers Credit Union was $1,301 a month. So she's already $701 a month in the hole. She's paying separately from her money.
I'm keeping in accordance with my ruling, I'm keeping in 11B. I think those are the, looking back at the amount per month, less the 600 per rent. I think those are the accurate numbers contained in the balance sheet. It is accurate that 11C declines an award of waste to either party. That will continue. But
So
I did specifically rule on her receiving those credits towards the value of the sale of the commercial property.
No, I understand that, Your Honor, but you didn't make any rulings on the amount of the rents. And that's where the discrepancy is. Because we both agree that that should be credited to what she paid, but the amount is disputed.
The $600?
The $600 is not disputed, that she received that much from February 2022 to May 2023. I don't think it's disputed that she received $625 from June 2023 to now. And I don't think it's disputed that the property was paid off in May of 2023. So we've got a total debt that was the $20,235, and then we've got the rents, which show that she should only be awarded, she's owed the minus $269. In their spreadsheet, they allocate another $20,000 of debt to her without credit.
So you're forgetting that there's still there was $13,100 still owed to Daryl McLean, and all of after
that's
the
listed in the spreadsheet separately.
Yeah, so on the spreadsheet where it has debts to wife, Farmers Insurance Federal Credit Union, 20,000.
Yes.
That's what you're referring to, Ms. Jeffers, correct?
Yes, that's what I'm referring to. And on my spreadsheet, I also have, if you look at my revised spreadsheet, the repairs and costs that they requested, the $14,852, and the debt to Daryl McLean. Those are on there. So we're not even talking about that right now. We are just talking about the principal on the building. And so it doesn't matter if she used her separate funds to make that, because at this point she's been reimbursed.
But she's not been reimbursed. That's the problem. So it is appropriate to identify the community debt at the time of separation, which is the $20,235 for Farmers and the $13,500 for Daryl McLean. Then what the calculation does is it takes into consideration what has her payments been from her separate monies after these folks separated. And it's inappropriate to put it up in her side of the balance sheet, because that's giving him 50% credit of her separate payments that she's had to pay post-separation. So we've provided proof of everything that she paid, not just these mortgage payments. We've taken into consideration the utilities for the past 2.5 years, the property taxes, the insurance, the repairs, all of that has been post-separation, and she's had to borrow money in order to pay all of those, with the exception of the sewer replacement. Some of that was paid from the monies that were in the safe, which we talked about, or which talked.
is saying is that when you look at the actual $101 over the course of those specific months, that is the 11,216 that she paid. And even if you,
I don't know if you have my client's court date there.
I do.
Okay, so if you take a look at, bear with me just a minute. So tab 18 is the $7,000 in repairs that she had to pay for the sewer system or whatever that broke down.
Your Honor, I'm unsure what we're doing here. Those, I put those in my spreadsheet as a debt.
I do see commercial building and repairs of 14,052.
So I'm not sure why we're going by these individually.
Yeah, I don't think there's just a dispute on the building repairs and costs. Where the dispute is on this, well, there's the primary dispute appears to be the allocation in Ms. McLean, your balance sheet of $20,235 towards the mortgage, when what Ms. Jeffers is indicating is that when you break down the $20,235 and you give her credit for the rents received, the deficiency is $269.
Correct.
So
that's what we're trying to clarify. So I don't want to go into repairs right now. I want to focus on this mortgage and the rents received to date.
So Ms. Jeffers' simplistic math does not include interest on that loan, does not include, does not include the additional payments that my client paid above and beyond, again, from her separate proceeds in order to get that paid off earlier, which is exactly what she did. And so we provided proof of that. Your Honor, specifically, when you looked at this, you said specifically that petitioner is reimbursed for debts paid post-separation to Farmers Federal Credit Union and to Daryl McLean. And that's the $14,020 that we corrected at the time of the argument in our court date. It said we were asking for the separate reimbursement of $9,113 through, it looks like, July of 2023.
So there's the expenses and then there's the net payments.
Yes. After receipt or after application of the rents.
I think, but in looking at the objection, that's where the difference lies. Is Ms. Jeffers is indicating that if you look at giving her credit for the rent, it comes out to $269 less than the $14,020.
I'm sorry, say that again.
Well, now I'm rethinking what I want to say.
Yeah.
I'm looking at Ms. Jeffers' objections. And how I'm reading this is that the building that we all agree, Ms. McCoy paid off the building.
Yes.
She made a payment of $20,235 in May of 2023, right?
Well, it was paid off as of May of 2020.
It was
yes. He just made payments, that $1,301 a month.
Yeah. So it was paid off. And then she received rents February to May that totaled about $11,000, June to July that totaled $8,000. And so the $20,235 minus 11 minus 8, the rents received is $269.
Correct.
Okay, but that doesn't also take into consideration the fact that she's paying water. These are not repairs. This is water, sewer, garbage, property taxes, insurance, above and beyond that. Because once that mortgage is paid, she has to pay all of that out of pocket, and we provided proof of that in the balance sheet.
That is in here. It says
yes, it is.
Paid accounting, electrical, insurance, water taxes, repaired, valued at $14,852. That's separate from what we're talking about right now. So I think I have to just pause for a minute. There's an urgent order I need to sign. Give me just a second.
Thank you, Your Honor.
Yep, we're going to go off the record just briefly so I can do this, and then I'll be right back with you. Okay. Sorry about that. I might have something handed to me in a second, but we could stay on the record. Here's what I'm going to do. I mean, we still have so many of these to go through. And here's how I see it. And again, I don't want to rehash this entire case, but I think Ms. Jeffers' calculations as far as the credit towards the mortgage is an accurate calculation. So I'm going to adopt that as the contribution towards the mortgage. So there's a $269 deficiency. However, I'm including Ms. McLean's numbers for the electrical, insurance, water taxes, and repairs valued at $14,852, which should be her reimbursement for those monies paid.
Okay, and I just want to clarify when you say reimbursement, because this is part of the problem, I think, is where Ms. McLean is putting it in, is that she needs to be directly reimbursed for that. However, half of those expenses are hers. But they're asking for 100% reimbursement.
Right, but my understanding and how I'm reading this case is that the $14,852 was no longer community money that she was using to make those payments.
That's correct, Your Honor. You're right, but she was still responsible for half of that debt with her separate funds. So she would only be entitled to a credit of 50%. In other words, there's a bill for $100 on our property. I pay $100 with my money, but only 50% is my responsibility.
No, she's getting a credit for $14,852, which is the amount of her separate fund money that was used to make those payments when he wasn't. So I am including that. But I'm instead of the $14,020, the amount owed to her towards her contribution of the mortgage is $269.
And I'm sorry, the only other question that I have on that is the fact that okay. All right.
Let's move on to the other points of objection. Rents the wife received during separation will offset the debt she paid. Did we address that in your 269 calculations, or is that separate?
Yes, we did. We're on number 3, the deadline for payment to husband.
The deadline for payment to husband for his portion of the equity in the family home. I did not address in my ruling. Is there a position from the parties, or?
Yeah, we think that it's coming out of the escrow monies from the commercial property. When you do the bottom line analysis, that's the language at the bottom of my balance sheet.
On the, let's see, rent home, under rent home.
Yes.
Valued at 3. Go ahead, sorry.
So if you take, her 80% is 304,000, his 20% is 76,000. On the analysis sheet that I had provided, and I'll make that adjustment for the 269, but on that analysis sheet, he would owe her, or I guess the adjusted transfer is that, actually I need to look at the correct one, bear with me. I'm looking at too many things here.
No.
He would get $3,000 from the family home.
Right, that's going to change though, because we're making that 269 change, so the
he
question
would get the first 3,000, and then the balance of the commercial property asset would be split 50-50. So he would get the first $3,251, and then thereafter it would be split 50-50. But again, that's going to change now that you've reduced that one.
Well, it's going to change based on the rulings, and that wasn't my understanding of the language, Miss McLean. My understanding was he's to get the $13,000 for Mr. McLean off the top before there's a split.
He's to get whatever is paid to Mr. McLean off the top. We're talking about just this one issue right now, but clearly you did. I don't think that. Okay, so he is to get whatever is still owed to Mr. McLean. My client's still been paying him monthly since the date of separation. So whatever, and I don't know what that amount is currently because she's still paying him monthly. So whatever is paid through escrow to Daryl McLean, because that's been included in the balance sheet, he would be paid that amount off the top. Whatever is paid in escrow to him, he would get that amount, and that's outlined in the decree.
And
Eric,
Your Honor, I'm going to object to that. That amount wasn't in evidence. I mean, at this point, we're talking about the wife's father, so he can say, oh, there's nothing owed to me, so that his daughter gets to keep the money and my client doesn't get credit for that amount. This is kind of what the amount before you and what is on both spreadsheets and what is agreed, and the evidence before you was that debt was $13,500. That's agreed. That's what she gets credit for.
You both have that on your spreadsheets.
Correct.
Okay, so I think the question in front of me, I mean, that number's on the spreadsheet, so there's no disagreement there. The question and the number to him is going to change based on the 269. So the question in front of me right now is, what is the deadline for payment to husband for his portion of the equity in the family home? So I want to address that. And it sounds like it's based on the commercial property selling. And we think that's going to be in 2 weeks, but that could change. So
I think we just say that they be paid from escrow.
Yeah.
And the escrow date would determine that.
What if the property doesn't sell and the property doesn't sell for another year? Then what's he supposed to do? Wait for his portion for that time period? We can say with
Go ahead.
We could say within 10 days of closing on commercial building, not to exceed 60 days. That's acceptable.
I'm sorry, say that again.
We could say within 10 days of closing on the commercial property, but no more than 60 days total. In other words, we'll give you time for it to close as long as it closes in 60 days, but it has to be paid within 60.
Well, my client doesn't have any liquid cash until that closes, unless the court gives her 90 days to see if she can qualify for a loan on the home. So the whole expectation is that they're both going to be settled out of the real property or the commercial property closing.
It's going to be 10 days. The payment's going to be 10 days after the commercial property closes.
Can there be not to exceed? I mean, it can't be like 5 years, right?
I'm sorry. So let me make sure that I understand. So, after the commercial property.
10 days after the property closes. Let's put a not to exceed 1 year. I think the exception is going to be, or the, I guess, caveat could be, if you all want to put it in the order, would be that
the expectation is that he's paid from closing.
The expectation is paid from closing, but we are putting a end date on that of 1 year. If it's not closed within 1 year, then she'd have to look at alternative sources like refinancing. Okay.
Next issue, Your Honor.
Okay, go ahead.
So, in the language here, as far as any refunds on escrow property taxes should be split between the parties. Wife is already receiving credit for that. That is explicitly under that $14,852. So given that she's being completely reimbursed for that, those costs should be split in half.
Well, and again, my client has continued to pay from her separate proceeds. She's the one that's lost the use of her separate proceeds. So if there's a refund of property taxes that she's paid, there won't be mortgage reimbursements because that would be whatever's owing to Daryl McLean at the time. So if there's a reimbursement of overpaid property taxes, those should be reimbursed to my client.
And Your Honor, there's no evidence of that. I mean, at this point, this decision is supposed to be based on what was before you on the date. If counsel wants to send me, that's fine. But right now, as of the date of this decision, she got credit for 100% of all of these things as reimbursement.
I'm adopting Ms. Jeffers' bullet point 4 under that. They'll split any reimbursements 50-50 for escrow and property taxes. We don't anticipate any mortgage reimbursement because we don't. Ms. Number 5 is both parties should be given credit for repairs and costs to maintain the commercial property that they paid, not just party.
That's correct, Your Honor. So husband presented information showing that he made several improvements to the property. There was a roof payment, electrical had to be paid. Advanced electric. He paid utilities, the commercial building insurance, and for a roof leak. So if she's getting reimbursement for repairs and property taxes, he should get the same reimbursement credit. It's pretty straightforward.
That credit.
The credit is, let me see if I put that on my spreadsheet. It's under $2,000.
At the 1,446.
I believe it is. That's it.
And I don't recall seeing evidence of any of that.
The receipts are in the evidence. If you want, I can go to the exhibits.
Yeah, I am going to adopt that. We don't need to do that. It is fair. We're going to adopt the reimbursement of 1,446.
Thank you, Your Honor.
Okay, life insurance. Wife should receive no benefit for the respondent's life insurance.
That's correct, Your Honor. I mean, basically, you know, what's kind of happening here is wife is pushing for husband to go to prison, and it appears she's hoping that he commits suicide or something like that based on
Your Honor, I'm going to object. One, that's not relevant.
Yeah.
Properly before. Counsel and I are not his counsel in the criminal case. Totally improper.
Yeah, so let's just stick to, you know, I looked at the language for the life insurance, and it's very uncommon that an ex-wife stays the sole beneficiary for a life insurance policy post-divorce. So I guess I'm just wondering why that would stay.
Well, one, we had been requesting that be provided as it relates to securing the. I'm sorry.
No, go ahead. I'm just following along with you.
We had provided as far as securing that weighted division of assets and debts. And again, that was our proposed language in our final orders. We discussed that at the time of the presentation, the fact that even under the scenario of spousal support, he had significantly greater Social Security earnings than she has, which should have provided for an equalization on this long-term marriage for the rest of her life. And so we think that is important, and she is the one that would be continuing to pay, or would be paying that monthly insurance payment in order to secure that. I think if I recall correctly, the insurance policy terminates, the natural termination date, I think, is in 2026. So given the long-term marriage, we felt that was appropriate. And again, the court didn't deny that in your ruling.
And it's June 2025, I think, is the maturity date. So I don't.
Yeah, it says 2025.
Yeah, go ahead, Ms. Jeffers.
Yeah, that's correct, Your Honor. I mean, I think that their intention was to make sure she got her spousal support or her post-secondary, but she's already got that on a weighted distribution.
And I think that is my exact thought here. I guess, you know, my preference would be that Mr. McCoy changes the beneficiary to his child, but I don't think that I am going to mandate that. And the reason I didn't address it in my ruling was because the language in the proposed order suggested that instead of a weighted distribution, that was the money that was going to be used as a backfall for all these other things he couldn't pay. And I feel like in my order, and the reason for striking the life insurance language is that I feel like with the weighted distributions, those concerns were alleviated. So I'm going to strike the life insurance language. That takes us to page 3 of the objections, balance sheet, value of vehicles.
Correct, Your Honor. So these are a lot of things that we just didn't get rulings on from you. Mm-hmm. So, I mean, both of us provided evidence of values of vehicles. We need you to pick some numbers there. And I think,
Oh, go ahead, Ms. McLean.
I'm sorry. Again, I guess to me, this in some respects smacks of a reconsideration. The court, as I understood it, was operating off of our pleadings and the balance sheet that we provided. As it relates specifically to the values that were provided for purposes of the informal trial by Mr. McCoy were more recent values, not values at the time of separation. So he's reduced those values for depreciation of his separate use. And particularly in regards to the boat, he provided no evidence as it relates to the fact that that boat was a gift. And then he argues that it was stolen, although if it was stolen, that is his issue. He has the ability. I didn't see where a police report had been filed and the like. So the concern is that those are values that were exchanged through discovery. And we believe that the court should maintain the values that we've adopted on our balance sheet.
Let me tell you, at least for vehicles, I would say most of the valuations I am taking from Ms. McCoy's balance sheet, but I'll tell you honestly, and maybe I'm reconsidering myself, but I do think where I got it wrong really is overlooking the wood valuation. I'm not adopting, and again, this is something that I overlooked at the original time of ruling, but when I went back and relooked at this before today's hearing, I am not valuing that wood at $37,700. I do think that is extraordinary.
May I be heard on that?
You can be heard, Ms. McLean. Go ahead.
So I would point out at our tab 44, we provided proof of his text that he had 22 finished tables. He had been selling wood tables in the Merc. He had 34 live edge tables. He had 34 live edge cabinets that were completed. In addition, we provided the pictures from the business where it showed that he was selling slabs as well as completed pieces, and that he has at least 6 wood slabs in the he says he has 6 wood slabs, but the photos show just from the shop alone that he had substantially more. And you also had evidence that he had purchased a whole tree that he's not accounted for. So given the fact that there are substantially more completed assets that were for sale that he is not accounted for, and we've provided that information, we do believe that the court should provide for that.
Ms. Jeffers, go ahead.
Your Honor, we provided the information from the expert valuing it at $2,000. All of those pieces still exist. Wife can have them at her valuation, but it's absolutely ridiculous to say that wife gets basically $500,000 in real assets. Husband gets, less than $100,000, a couple of pieces of wood, and 2 old cars.
Yeah. Yeah. I mean, here's the deal. I am adopting primarily the wife's valuations. I think it is supported by the record, but on this wood, I am going to value that at $5,000. I think it's probably a little bit more than his expert, but again, I think a lot would have to go into it to get to a $37,700 value. So I am revaluing that at $56,000. I'm sorry. Sorry, I said 56,000. I wrote 5. I meant
5,600.
But 5,000.
5,000. Okay.
5,000. I apologize. It has been the longest day, and I have a screaming headache. So yeah, not 56,000. 5,000. We already took care of F, which is the repairs for the commercial building credit.
Yes, Your Honor. What about the salon? The $10,000 valuation on the salon, the valuation was based on the fixtures that are being sold as is with the business. The business is being sold for $190,000. Either that should be deducted as something for him, or, at this point, he's not getting that $10,000 because it's per your ruling being sold as is with the fixtures.
So again, the value of the business did not include fixtures because that would go with the commercial building. The value of the business was based upon all of the product and assets that he had within the business, as well as his bank accounts, which we accounted for within that salon value. If you go back to the evidence that we produced, you can see photos and photos and photos of him selling assets for significant amounts as far as product and the like. My client is renting a space. He was an operator owner, which means all of the other tangible assets, not the fixtures, were included in the business valuation. And yeah, so that's
I agree. I'm leaving 10,000 in there. I want to go to the money with the G. Petitioner took 19,000 belonging to the couple out of their safe. Ms. McLean, you want to be heard on that?
Sure. So first off, if you go back to his response to the petition, which we filed at our tab 44, said that he at that point acknowledged that there was $7,000 in the safe. Now it's blown up to $19,582. Keep in mind that $4,800 of that $7,000 was the separate monies that my client received in November of 2021 under COVID relief. And she told you that specifically. And we provided proof of her COVID grant at tab 68.
Ms. Jeffers.
So, Your Honor, we provided all the documentation showing the withdrawals from the bank account, from the community accounts for the cash that was put in that safe. He testified to that. If you look at wife's income, which is about $15,000 a year, and the fact that she paid off like $40,000 of debt in 16 months, it's obvious that that money was not coming from her wages. So that was the amount that we could prove, and that was the evidence submitted.
And I guess I would just remind the court that obviously Mr. McCoy was working at that time, earning substantial amounts of money, which is what would have helped to pay their community debt at the time that they were together.
And Ms. McLean, you said the most recent indication was 7,000 in the safe.
Yes, of which that's what he claimed. We provided proof. If you show, or if you look at my client's declaration, so the court aid and whatnot at page, bear with me. This is page 5. She indicates that there was 4,000 in the safe from the grant that I received. Tab 68, these monies were spent to pay the sewer line bill to repair the 14th Avenue sewer line. Husband then vacillated in the amounts of cash he claimed were in the safe. His response to the petition claimed there was 7,000 cash saved in the safe for a vacation, and then he claims more cash was saved, which I'm unaware of the amount the petitioner dominated the financial purse strings. So we provided proof of the $4,000, but that has obviously subsequently been spent.
So, Your Honor, I mean, at this point, I mean, when you listen to what they're saying, like, oh, well, we used that amount for these repairs that she's then being reimbursed for because she paid with her separate property, that wasn't separate property. So she can't have it both ways. She's got to take responsibility for the money she took out of the safe, or she can't get reimbursed for using community assets to pay community debt. And we provided all the bank statements showing that exact amount.
Well, I understand ruling on the reimbursement for the 14,000 sum is based on my belief, more likely than not, that the 14,000 was separate post-separation money, not community property. Given his response, he will get a credit towards, or she'll be debited, however you all want to put it on the balance sheet, $7,000 of the community money that was, well, 50% of $7,000 that was the community money that he admitted was in the safe.
Versus her admission of worth.
Versus what?
Versus her admission that there was only 4,000, and the fact that as of November of 2021, we produced the evidence that she received the $4,800 grant for her business, and these parties separated 2 months later.
Yeah, we're gonna talk about the grant in just a minute, and what I'm taking into commissioners has receipts that shows more than 7,000, but his initial valuation was 7,000. Her statement was less. So I am splitting the difference here and finding a middle ground for the parties that I think is more likely than not appropriate. And that's that they'll each essentially get a credit or debit for, depending on who got the money and who didn't, of 50% of $7,000. And this is safe that I would deem community money, community asset. H 2020 tax refund.
Yes,
So
we should. Go ahead, Ms. McLean.
So the balance sheet suggested the 2024 tax refund, which was a refund of 48.
4332.
Yeah, that 4332. So 2021, she filed separately in 2022, which is her right. He filed separately in 2022 for the 2021 tax year. And so that should be considered her property. And the court should not, I mean, she has the right as an injured spouse to file with the IRS in that manner.
And Your Honor, we're not talking about 2021. We're talking about the 2020 tax return. They filed for taxes together. He was arrested. He wasn't allowed back in the home. The money was direct deposited into their community account, and she transferred it into her personal account. And we submitted the bank records to show that.
Yeah,
he could not. He was in jail.
Because it is 2020, he's entitled to 50% of the 2020 tax refund. The amount is agreed at $4,332, so he's entitled to 50% of that.
Your Honor, the evidence shows the 2020 tax refund was $2,891, and he paid no child support from January through June when Maddie was still in the household.
Then I have something wrong in mind because
I've got the tabs.
Look at tab 3 in my court aid.
It is true, the 2024 tax refund, if that's what we're talking about, or anything.
Just 2020.
We haven't filed 2024 yet. We're still in 2024.
Well, I know, but the balance sheet is listing it as 2024, but the pleading listed as 2020.
So the 2020 tax refund was $2,891. It's tab 3 of our evidence.
Well, I'm just wondering if I mislabeled it as 2021. I'm looking here.
So 2021, the parties filed separately. My client received $4,322 and Mr. McCoy received $255. They filed separately.
No, I'm showing in my exhibit, the refund from the IRS was deposited on March 30th, 2020 into the joint account when he was in jail. The amount of that was $4,322.
Okay. These parties separated in 2022.
Or excuse me, 2022, 3/1/2022. So I must have.
And that's my client's separate tax filing. Tab 4 is my client's 2021 tax return, and tab 5 is Mr. McCoy's separate tax return.
So did he file separate for the year?
Yes.
I guess, and this is where I'm having the confusion, is it's labeled as a 2020 tax refund, which would obviously be.
Right. I think they both agree that it's community here.
But if we're talking.
Okay, so I've got their 2020. Let me take a look. 2021. 2022, it does appear that she filed separately, but she claimed their daughter. I mean, I guess it was his understanding that that was community funds, and it was. I mean, it was earned during marriage, so there's no question it was community.
Yeah, I'm going to deem that her separate property. There won't be reimbursement to him on that issue. Moving to I, the court did not address the community grant. Wife kept in the amount of 4,800. That amount should be awarded to her. And then there's some subsections underneath, but I think that we might have already dealt with the commercial property. I think that's showing up in two places, but
yes, with regard to the community grant, that was something that was applied for before they separated. She did get those funds after they separated, and the court just didn't address it.
That's again not accurate. If you take a look at tab 68, that is the community grant. It was dated November 23rd of 2021. It was under her business name, which is Salon at the Park, and it was $4,800. And my client tells you that those were the monies that were deposited into, she cashed it, put it in the safe. And at the time of separation, there was $4,000 of that the $4,800 left in the cash. That's her direct testimony in her court aid.
And that money is going to stay her separate property. I also think that some of it may be part of the money in the safe, since it appears like it got added to the safe. I've already given him a 15% credit for up to $7,000 in there. So the 4,800 community grant remains with her. It was in her business name. You said November 23 of 2021.
So then that takes us down to J, Your Honor, and the last page here.
Okay.
So in your ruling, you specifically said that the wife got no credit on the family home for paying the mortgage or anything like that. On their spreadsheet, they put that on there, that she got credit for that.
And that is inaccurate. If the court takes a look at your ruling on page 4, you indicated that provided that such division is made after petitioner is, oh, I'm sorry, wait. It's at the top, it's at the bottom of page 3. Petitioner shall be responsible for all debts and expenses of the property and is not entitled to any reimbursement for expenses incurred on the property from the time of separation. We were asking for expenses at the time of separation. There's still a mortgage. It's a community mortgage. My client has since paid that community mortgage of $18,968. Well, again, with her separate earnings. I've kept it up in the community portion, though. She should receive credit for that. There's absolutely no reason why she shouldn't receive credit. I think what Your Honor was referencing was the fact that we were asking for the court to take into consideration the fact that there were all of these anticipated repairs, as well as repairs and stuff that she's done with regards to the current heating system and the heating unit and the things like that.
And Your Honor, the case law is pretty clear on this one. I mean, she is paying substantially less for living in the family home than she would have in rent on the market. So she doesn't get any credit for that. That's case law that establishes that. And that seemed to be a ruling. It is my understanding that house is paid off and it was paid off prior to us going to the MSC in this case.
And then Ms. McLean, where on the balance sheet are you valuing that?
The Wells Fargo, so under debts to her, it's the one under the farmer's insurance at the $18,000. So it's Wells Fargo, Ren, $18,968.
Oh, there we go.
And again, she was paying that post-separation with her separate monies, although I've identified it as a community debt, so she would only receive credit for that as a community debt. The party's child was living there until her graduation in June of 2022. And again, the court did not award my client any child support during that time, even though clearly the court had jurisdiction to allow for that. And he's been the substantial breadwinner during this time. I'm not exactly certain what case law counsel is referring to, because the court's to take into consideration assets and debts at the time of separation.
And Your Honor, we keep hearing this, no child support. There's only 5 months that my wife would have been entitled to it, and my client was in jail. So, I mean, at this point, again, I believe that your ruling is clear. You don't get credit when you're paying less than you would pay for rent on the open market.
I'm not aware, again, I don't know what case counsel is referring to. Because again, the court is to take into consideration assets and debts of the parties. And my client has paid that with her post-separation. And keep in mind, she qualified for a low income grant, or I'm sorry, that was COVID relief, not low income, although it does talk about low income in there. And my client's earnings compared to, she's less than half of what his earnings were.
Your Honor, your ruling is what it was. And if you want to take into consideration assets and debts, at the end of this, she's going to own a home pretty much free and clear. He's going to have less than he could buy a home with. She's going to have all the cash the parties had, all of the retirement accounts, etc.
I think the difficulty I have is that giving her the credit for that $18,000 is essentially a double dipping, because she also has a majority of the value of the home and those payments, and that asset is going to continue to appreciate for her, and she's the owner. So I am reading through my ruling, and I think what I was making very clear was we understand that she had to do these things to maintain and repair the home, but she would be responsible for those because frankly, she is getting a substantial portion of the marital estate. So I am going to strike the Wells Fargo portion to her. The K under wife's attempt to claim mortgage payments on the commercial property twice. Did we already deal with that, or is that something separate?
We did deal with that, Your Honor. And then, I mean, my conclusion is kind of the conclusion. So I think we just need to go through the numbers and see where we're at with the new values.
Okay. So with the changes we've made then, and I know Ms. McLean, you are leaving town ASAP, I think. Is that right?
So I'm in a golf tournament tomorrow and Thursday, and I leave town Friday. I'm not going to be in the office again until I guess if I have to come back into the office during the balance of my vacation, then I will. Well, but I'm not back in the office I could not be back in the office until the 29th.
That's okay. We'll try to make your vacation work. I'm fine.
Property is supposed to close on the 30th. So if we're going to give instructions to escrow, we need the orders entered before then. So I will make these changes and get them to council tonight. And I guess we'll see if we can't get an agreement, or if you want to give me a couple minutes, I will. I've been making the changes to the balance sheet here.
You can certainly send them over to me. I mean, if they are consistent with the court's ruling, I'm going to sign off.
Okay. Are you available to do that tonight?
I'm supposed to go into a meeting in 23 minutes.
Okay. So let's see what I can get to you in 23 minutes.
Okay. Sounds good. And Your Honor, do you want a review date just in case?
So why don't we do this? Do you all want to email me later tonight? And just, the two of you, me, and either it's going to be orders that are ready for me to print and sign and file, or you're going to say, hey, there's something we need to address and we can get you a review date. What's your preference?
I don't really have a preference, Your Honor. I'm just, I guess I'm a little concerned that I'll be able to get through everything in 20 minutes. I'm going to try.
Yeah, I mean, like I can't juggle too much around escrow dates and that sort of thing. So you all tell me what you need. Do you want to wait and see how far you get on the emails, and hopefully they are ready for me to print and sign and file tomorrow morning?
Sure, I guess.
That's fine. Or if you want to set a review date for the 30th and we can strike it if we can enter agreed orders.
Are you back on the 30th, Ms. McLean?
I can be back. I mean, my vacation has already been interrupted by 5 days. So I guess what's another one?
Well, we're not trying to put your vacation out. I know, believe me, I know how hard it is to take a vacation in this profession. So you all tell me what,
Yeah, put it on, I guess, put it on for the 30th, and I'll just hope that council can sign off.
30th at 1 o'clock.
Okay.
Okay, I'm gonna put it on, this one will be a separate commissioner presentation. It will not be on family law docket. So I will send an email out to Jalen about that right now.
Thank you.
And you can both just email me and I'll strike it if we have agreed orders anytime before the 30th.
Thank you, Your Honor. Thank you, counsel.
And I'm happy to print those orders. They don't need to be filed. I'll print them and sign them and give them to the clerk.
All right, thank you.
Okay. All right, thank you both. Okay, anything we're missing? All right, I will go ahead and end docket.